The context of this debate today, of course, is the COVID pandemic. So we do have a different scenario where people are using much more technologies. And of course, also governments are relying on technology to fight this new, let's say, challenge that this virus pose to society. So one of the main tools that governments, they realize as an effective tool to fight this pandemic is the use of social distancing. So putting people aside. So myself, I'm based in Italy, so we had to stay at home for more than 2 months. And of course, it had consequences in different parts of the globe. Some countries in the South Hemisphere are still facing the need to, let's say, to quarantine and so on. And of course, then after the social distance, one of the tools that were, let's say, selected by governments to somehow ensure that people could go back to their normal life, so it's still to this new normal life that we are living today, was exactly the use of tracing technologies and tracing applications. And it's in this context that we'll be discussing the possible consequences, the difference in terms of technology, the data protection implications, and then the broader legal issues surrounding the use of these technologies. I'm just like making a brief comment on the different types of using this sort of location technology and contact tracing technologies around Europe. So different data protection authorities, of course, the European Data Protection Supervisor also made a statement on this, but the different data protection authorities in different EU member states, they somehow divided two types of data processing activities that could be useful to the fight of the pandemic. The first was mainly the use of location data, let's say, to create modelings and models to spread, to contain the spread of the virus and to assess somehow the effectiveness of these confinement measures that we faced in the last months. And then the second step was much more on the use of contact tracing applications and technology in general to ensure that people could go back to normality, and then with the idea that they could break the contamination chain of the virus by informing people whether they were in contact with someone that was supposedly contaminated by the virus, and then that person could get in touch with the local sanitary authorities and health authorities and somehow break the contamination of this chain. So we do have this scenario where governments, they are using both location data for the creation of models, so mathematical models to assess the effectiveness of the measures of confinement, and also to monitor somehow the compliance with the rules that were adopted in different member states. And then the next step was exactly the contact tracing technologies, which are the focus of the debate today. So I'll just point to three main concerns that were identified, so have been the focus of debate around Europe and around the world, which is the consequence of the use of these technologies regards the monitoring of millions of people, so and even billions if we take into account different countries around the world. And of course, we are not only talking about democracies as we see in Europe, so we have countries with no specific guarantees, no data protection rules, no, let's say, enforcement of fundamental rights. So we do have like the concerns in terms of monitoring. We also have an issue regarding potential discrimination of contaminated people. So there was this debate around the possibility of like making people undertake blood tests to see whether they were contaminated or not, if they had already anticorps to the virus. And in that case, these people would have to show their, let's say, certificates and inform. So we would create somehow a sort of like blacklisted and whitelisted workers that could go to work if they had already taken, were already contaminated by the virus. Then, of course, one of the let's say, the most important debates around the use of these technologies, which somehow shaped the different choices in different EU member states and in different countries around the world. We got the potential breach of privacy and data protection. So we'll also have the opportunity to hear the views of the EDPS, and also of other fundamental rights and other legal issues around the use of this technology. So the problem around monitoring of people and the possible future use for different purposes by governments if they collect a huge database of people with location data of all individuals, with like tracing the contacts of these people. So it has some concerns regarding the different legal aspects. I think I'm to stay within the 10 minutes. I think I'm now moving to our first speaker. So since we have a very, let's say, mixed composition, although we just have 3 speakers, but they have different expertise. So we have first Professor Paolo Boldi addressing the technological issues around the use of the different technologies for contact tracing, so GPS, Bluetooth, and the difference between the technology employed, but also in terms of concentrating, let's say, this information in a centralized repository, or whether using a decentralized repository would be also a possible solution in terms of exposing people's identity. So the floor is yours, Professor Boldi, and then you have 10 minutes. Then I'll go back to Dr. Wojciech for his talk.
Thank you, Mark.
The floor is yours.
Thank you. Thanks for your questions. Let me slightly broaden the questions that you wrote in your slide. As you correctly said, contact tracing is about storing somewhere enough information about personal contacts of people so that if somebody gets tested positive to coronavirus, you can go back to all the contacts that person had during the time window of infection and warn them about the fact that they may be positive as well. This is the functionality that you want to implement. It's called contact tracing. But there is an uncountable number of ways in which you can implement this functionality. And each of them gives rise to different different impact to privacy, to precision, and so on. Let me give you just 2 examples at the 2 extremes of this spectrum. On one extreme, let's say on the most intrusive extreme, you have the so-called network-based solutions that were adopted in Israel, for example, or in Korea. Those solutions don't even require that you have an app installed on your cell phone. What they do essentially is tracking your geolocation at all times, either using GPS or even without GPS, using mobile phone cell triangulation, credit card information. So the point is they use all the technology that they can use to get your position at all times. And they store in a central place the trajectories of all cell phones, essentially of all citizens. Now, once you have all this amount of information, you can do, in fact, much more than contact tracing. You can do contact tracing, it's easy, because if you have all the trajectory in space-time, you can do contact. But you can also do location, what you call the location. You can study how the virus is spreading. On the other hand, you are collecting much more sensible data and much more data than you strictly need for contact tracing. The other extreme of the spectrum is the set of applications that are inspired to privacy-preserving contact tracing, which is, by the way, a well-known and respected field of research in the last decades, much before than the COVID pandemic started. Just to give you a concrete example of how those applications work, let me use the Immuni application. That is the one that the Italian government decided to adopt, but the others are just variants of this. So if you install, you first need to install the Immuni app on your cell phone. You must be sure that it's running, because you can stop it and restart it. And you must be sure that the Bluetooth is activated. So once you have all these things set up, what happens is that the app generates an identifier every 10 minutes. So every 10 minutes you have a new identity, which looks like a random number. The only place where your identity is stored is on your device. It's your device that is generating it. When you get in close contact with somebody else who's also running the Immuni app, what happens is just that your current identity is stored on the other person's cell phone and the other way around. So at the end of the day, what you have on your phone is a list of identities you met, at what time you met them, for how long and how close, approximately. But those identities cannot be traced to any particular individual, because it's only stored on the device that generated it. When somebody gets tested positive for coronavirus, with the help of some health authority, they send to a central server the identities that their device generated along the window of infection. So there is this central storage of bad identities, of dangerous identities. And all Immuni apps query that central repository every night, let's say, to check if there is some dangerous identity that they have met. And if they find a match, they will tell you, oh, at 2 o'clock 4 days ago, you were 1 meter far from a dangerous person. Please get checked for coronavirus. I gave you these two examples because they use a different kind of technology. One uses GPS, geolocation. The other one uses Bluetooth low energy. They use a different way of storing information. One is totally centralized. The other one is essentially totally decentralized. And there are also other variables that come into play when you want to classify these solutions, right? So one is, as I said, technology, GPS or Bluetooth. One is centralized versus decentralized. Another one is, which is very important, is open source versus closed source. So do you have availability of the code of the application that is running or not? Because if you can read the code, you can actually see what it does and where it stores data, etc. Whereas closed source, you must trust what the authors of the application say about it. Another important point is how much those applications rely on external libraries to work. For example, the Immuni application is open source, so you can go to GitHub and read the source code, which is written in Kotlin. I did it. It's quite easy for somebody who programs. But the problem is that Immuni is just a facade built on top of an API that was released by Apple and Google. It's called Exposure Notification API. This API is not open source. So Immuni is open source, but the critical points rely on some closed source thing. And in this case, we must trust Apple and Google of what they do. Now, it's unlikely that they do something nasty, but who knows? I mean, their APIs are not open source. And probably another point is, as I said, it's not much a matter of technology, because you can think of privacy preserving solutions based on GPS, although I'm not aware of any of them. The difference is more on the side of which data are stored, where they are stored, for how long, who can access that, and so on. So it's more centralized versus decentralized, or anonymous versus non-anonymous, more than GPS versus Bluetooth.
Thank you very much. Thank you very much, Paulo. I think I'll just put again I'll share the screen again just to point to the question to Dr. Wojciech, and then for him to give his views on the use of technologies from a data protection perspective. So as I mentioned in my brief presentation, so one of the main concerns regarding the possible negative impact on people's privacy and data protection, I think the one better than Dr. Wojciech as let's say, the main watchdog in Europe regarding data protection. I think he's in the best position to give his views, and of course, EDPS's views and recommendations on the use of tracing technologies for the fight against COVID pandemic in different EU member states. And of course, highlighting the main data protection implications in this regard. The floor is yours, Dr. Wojciech. Thank you very much for being with us today.
Thank you very much, and thank you for the possibility of to be with you and to present this European approach to the subject, but also the data protection approach. I'm absolutely aware of the fact that you have enormously good specialists in Italy dealing with this subject, and I have to say that Garante has been involved in the activities connected with checking different kind of software that was proposed to help in fighting with COVID from the very beginning. Let me say at the beginning, for those who are less familiar with the very complicated hierarchy and organization in the European Union, what is a European Data Protection Supervisor? We are actually the supervisor of the EU institutions, bodies and agencies. So simply, we have still 27 different jurisdictions in Europe as far as data protection is concerned. And the Italian Garante is the only one who is responsible for supervising the data protection, also according to GDPR, according to General Data Protection Regulation in Italy. But at the same time, there is a European Data Protection Supervisor who is dealing with the data protection in the institutions and agencies of the EU, no matter where they are located. But what is more important for our discussion today, we are at the same time the main advisor of the EU institutions, especially those who are taking part in the in the legislation process. So both for the Commission, for the Council, and for the Parliament, when they are taking any legal actions and they are preparing any legislation. And what is also important, we are providing the secretariat to the European Data Protection Board. And the European Data Protection Board is gathering all the data protection authorities in Europe in order to harmonize their approach. And I guess this problem of harmonization of the approach is one of the first that we will actually touch when we will start to talk about the applications and different kind of use of the contact tracing. First of all, we have to remember that contact tracing is something much larger than contact tracing using apps. Contact tracing is a normal procedure which is taken by epidemiologists to fight the spread of the epidemic. And there was no need to have the applications to start the process of the contact tracing, and it has been started already at the very beginning of the COVID crisis. So the tool that we are preparing right now, or right now rolling out in all the European countries, is a tool to help in the contact tracing. So this is not a silver bullet which will solve the problem of the contact tracing, even not the one that will solve the problem of the COVID. But I have to say that the proposals, the expectations that the epidemiologists have towards this kind of tool make me, as a data protection supervisor, one of the first person who will download such an app. So I'm the one who will download this app on my telephone when it's available in Belgium, or when it's available in my country of origin in Poland, or in any other country that I will be present at. But at the same time, I will be one of the first who will ask, do you really know what you do? Do you really know what is the purpose for which you are collecting the data? What data you are collecting, for which purpose? Who has an access to this data? And what will happen with this data? So will this data stay forever? Will this tool stay forever? Or, as it should be and as General Data Protection Regulation envisage, in the extraordinary time of the crisis, of the health crisis, we are using extraordinary measures. And once the crisis is over, or we are in the control of what's going on, we know how to go out from the solution that we have. You probably heard that the Norwegian Data Protection Authority has stopped the dissemination of the application in Norway a few days ago with its decision, and which was quite surprising for many around Europe, especially that Norwegian Data Protection Authority was taking part in the preparation of this application. So why did they stop this activity? Because they found out that once the data was collected already from April, there has been no use for this data. Nobody used it for any purpose. There were some test actions that were going on in Norway, but actually the purpose has not even been tried to be reached. Yeah. So one of the first things that we have to remember about is what we are doing it for. And if it's useful, let's do it. It's really something that may help. And it may help if we all will try to use it. But we will use it if we trust. And the trust is the incredibly difficult question which is appearing here. The data that was revealed by Fundamental Rights Agency 2 days ago show that already before the COVID crisis, the trust in processing the data by the public authorities in the country was generally much higher in each of the EU country than the trust towards the companies using the data. So surprisingly, with all the doubts that the people in Europe have towards their governments, they are rather more trustful as far as the authorities are concerned. But of course, it differs from country to country. There are the countries where there is a generally very big trust towards the government, and those that are, let's say, more doubtful. And well, funny enough, both Italians and Poles are of those who usually ask the questions to the government and are not that very trustful towards the government. But the governments were working on this for years. But every mistake that is done by the government in implementation of the COVID tracing, so the contact tracing application, will be the disaster for the trust for the future. So my main advice to the government is please do it carefully and do it openly. Because I have to say that I have gained a lot of trust to Singaporean government, which never was my favorite constitutional order, and not my favorite management of the state, but I got a lot of trust towards them. Why? Because they made an open source application. Moreover, they decided to assess it. And after several weeks of using that, they made the perfect assessment saying, we didn't achieve that, we didn't achieve it, and we did achieve something. So what should we change? How should we deal with it? And here comes the other topic that I would like to raise in this discussion and maybe leave for the discussion after that as well. Because we are trying something that we don't know if it's effective, if it's efficient, if it will give us the real effect. But as I said, it's really worth to try. Even if there are the examples of a failure with the applications in Sierra Leone or Kenya or Ghana during the Ebola crisis, we have to remember that first of all, that's another disease, which is the Ebola, which epidemiologically is different. And this is another culture of using the telephones as well, which makes it very difficult to compare. So let's try in Europe, will it work? But I'm afraid that in most of the countries, the results will not be satisfactory. And I'm a little bit afraid of the second wave, but not the wave of the COVID, of course, I'm afraid as well, but second wave of applications. The second wave of applications which will give more features, because the people will say, okay, there was no problem with contact tracing, but it doesn't work. So let's do something more. And there are especially two things which I'm afraid of. The first are so-called immunity passports, or the green lights, or whatever else created this way. And the second is that the particular uses of the mHealth applications, which might be connected with this application that we have so far. Well, mHealth by itself is not bad. Of course, it's good. But the problem is who has an access to the data which is collected by the person about himself or herself. But let me talk a while about this immunity passports, which starts to be more discussed in Europe. I have enormous problems to understand what we are talking about. If the epidemiologists, biologists, and the doctors of medicine are not sure at the moment if you can at all be immune, if the fact that you have antibodies says something about the possibility of getting infected in the future, you have to remember that the people who are HIV positive, they also have antibodies against HIV. This is what we test. Yeah, we test this, and out of this we know that this person is actually able to infect the others. So the fact that somebody has antibodies does not necessarily mean that that it solves the problems. We have too less information at the moment to say when can we give the green light. Moreover, the green light given now maybe something maybe not necessarily as valid in few hours or few days. So be careful with going farther than we are at the moment. And at the last and the end of this discussion, I think this presentation, I think that what we have to work on and what have been shown that it doesn't work well in Europe is their interoperability between the solutions which are proposed by different governments. A lot to say about the differences that exist in Europe, a lot to say about the possibility to have the all-European app. I don't believe we can have all-European app, but we are missing the interoperability framework between the countries. I'm happy to hear that there are several countries who are discussing about it now, as a little bit under the umbrella of the Commission, but also on multilateral level, also outside of the EU. I heard today about this discussion between the representatives of UK and Germany. I'm sorry I'm speaking too long, so I'm finishing at this moment.
No, thank you very much, Dr. Wojciech. I'm pretty sure that you have more time for the debate, and then we can further discuss these issues. I will now pass the floor to Professor Curtin. I think it's really I think the best expert we could have in that moment for closing this first part of the debate, because we have the technological part, and then we have a more specific approach from this, let's say, the supervisory authority on the data protection implications. And now I would ask Professor Curtin to, let's say, to address the more, let's say, general legal issues, so the broader issues that can arise from the use of such technologies, more or less following up on what Dr. Wojciech started to discuss. So we are really concerned about data protection, but there are other issues that could be, let's say, could arise from the use of such technology if they are combined with different technologies and so on. So the floor is yours. I'm really happy to have Professor Curtin speaking in this webinar. Thank you, Professor. The floor is yours.
Okay. Thank you very much, and thank you for having me. I'm delighted to participate in such an interesting event. So I will broaden it a little bit beyond even legal issues, because that is necessary. A number of the issues have come up already, but I would like to emphasize them. First of all, the role of private actors, such as Google and Apple. It's already been referred to, but their role vis-a-vis democratically elected governments and their public health officials in determining, in a sense, what may or may not be on an app. Do they get to design software that cannot, for example, be easily erased or deleted? Do they or public officials get to share data beyond the specific purposes for which it's been retained? And what can informed consent mean in a context where there is no or little information, little control over personal data, and little or no explanation of app-produced output? So these are, in a sense, the broader panorama, and I think it's important to raise it in this context because it's about also the power exercised by these private actors and the broader context in terms of sharing and in terms of the role which citizens, individuals can play in consenting or not. Now, a number of the issues, but I just very briefly, before I go on to look at a number of concerns, I think it's very important that the contact tracing app, so now I am looking largely at the apps. The purpose of the data is not to replace, but to supplement manual contact tracing. That's already been said by the European Data Protection Supervisor. And its interaction with it is very important. Also, the human involvement, that it's not automated decision making, but there is a human involvement. Also, the issue to be clarified is the extent to which the users of the app, their movement is being traced as such, or whether it's proximity information relating to other users. The specific purpose limitation has already been referred to. So there are a number of legal issues in terms of purpose limitation, time limitations, and transparency, both of the codes, the algorithms that are being used. The first speaker referred to open source, closed source. I think this is really important in the fact that the APIs are not open source, but are always closed source. So there are a number of levels at which transparency is important. Also, in terms of if the data is made anonymous, what is the methodology that is used in that context? Because, for example, the e-privacy directive requires anonymization if it is to be transferred. Otherwise, it's the GDPR which applies. So what I would like to do, just to broaden the debate beyond privacy and data protection, is to stress, for example, the possible breach of the principle of equality. I mean, also in the report that the European Data Protection Supervisor referred to from the Fundamental Rights Agency the other day, stresses the divide in Europe in that regard. And I think this is really important because there is a digital divide, whether it's among elderly people or young people or refugees and asylum seekers. There are a lot of more vulnerable groups that may not have the same access to the the technology. And what does that mean in terms of those excluded groups? And are there not non-digital alternatives, for example, low-tech wearables that might be easily accessible to all? So I think this is a principle that also requires attention, the principle of equality. And the other principle that is important more generally, but also in the context of the European Union, is the issue of freedom of movement. If that is wrongfully or unnecessarily restricted, For example, if there is an inaccurate notification, for example, because there's a wall or something between the, which cannot be taken into account between the users, that there might be false positives. And so the restriction on freedom of movement might be completely unjustified. So it's important that procedures are in place post-notification in terms of access to tests, follow-up. And here again, I would stress the need for human involvement, not just fully automated decision-making. That's really important. But where the panorama, where this is all leading, and I think the broader context, and it has been referred to a couple of times already, is in a sense what I would call almost emergency leapfrogging, in a sense, so that one thing easily leads to another in a way that cannot be anticipated or controlled in advance. And we've seen that, of course, over the years in the context of other emergencies, how what is adopted during the emergency can become you know, the new normal, in a sense, that simply is the point of departure when everything gets back to normal. And I think there's a real issue also in terms of the perspective of surveillance here. And I think it's very important to talk about things like, obviously, about limitation in time for what is proposed, and also for the data being retained, also that it must be possible for users to erase the data, and the certainty that if that can then be definitive. Purpose limitation is incredibly important, and I think that's a conversation that we need to talk a lot more about, because, for example, we saw in Minnesota recently that the location data which was gathered during Black Lives Matter protests were used to profile participants. So there was a law enforcement dimension to it. And one must be very careful about that, because obviously interoperability, as the European Data Protection Supervisor said, is very important, and particularly at this stage in terms of making the apps across in Europe member states compatible with one another, so that there can be transmission, so that there can be effective coverage, but also that does need to be regulated in terms of how that is done and for what purposes it is used. The data is exchanged by national health authorities. The certainty that it cannot and will not be given to other authorities for other purposes other than health, that there will be no access or sharing, for example, for policing, border and migration control. And it's a slippery slope. I mean, we've seen there's been a lot of debate in the European Union level about interoperability, not only on a technological level, but also about the exchange of data across systems, as it were, you know, making data available, sharing data for law enforcement for purposes, migration, all of that. So I think that is a highly relevant debate in the context of this one. So basically, to conclude then, I would say that transparency is very important. It's key for the apps themselves, the codes used, the sharing, the anonymization techniques, the use of sunset clauses, all of that. I've already said, so no fully automated decision-making, that is, but it's used as a supplement and an aid to human decision-making and control. We haven't spoken about that much, but the role of data controllers in this context is very necessary. Then only necessary, proportionate and coordinated measures to restrict travel and reintroduce border controls. So a large emphasis on necessity and proportionality in that context. The need for legal procedures, in a sense, to be put in place to lay down mandatory conditions in various respects, time limits, purpose limitation, all of that. And obviously, in terms of equality, a duty of care to the vulnerable and the digitally challenged. And finally, and very generally, the rule of law and compatibility with the legal provisions, and in the context of the European Union, with the European treaties more generally. So I'd leave it at that. Thank you very much.
Thank you very much, Professor Dirk. I think you really set the floor for the debate, because many of the questions that are coming to different speakers, they really they step on what you just said in terms of transparency, data accuracy, and so on. So I will start with some more technological questions for Professor Paulo. So we have two questions here. One exactly related to the accuracy of the data. So if Professor Paulo could say, in terms of distance measurement, what is the accuracy for example, for the use of Bluetooth technology? So it's let's say a mixed question. Is it true that TAP's accuracy may be device dependent? So the type of device you use, we will, let's say, ensure a different level of accuracy. And of course, it has an impact on what Professor Dirk said in terms of false positives, for identification of people in contact with contaminated people. So she also mentions that in the UK, the NHS app for tracing would not work because Apple would not change its system in accordance with the app. And while it can measure distance, the app can't measure distance well enough to a standard that the NHS would be satisfied with. So do we have this difference in terms of the use of technology, but not the technology for the tracing that is decided by the government, but in terms of the technology of the user? And of course, I think it also relates to what Dr. Wojciech mentioned about the use of contact tracing technologies in Africa, where we know that the access to, let's say, to different mobile technologies much, let's say, in a lower level than in Europe. So is there really a difference between the types of mobile phones that we use for the accuracy of these technologies?
Yes, so neither GPS nor Bluetooth were conceived to really detect contacts. So in a sense, we are using two technologies that under that viewpoint are not accurate at all. Bluetooth is inaccurate in distance, especially in the indoors, and especially in the presence of obstacles. So the problem is that if the distance is less than 1 meter or 2, on most devices, the precision is very good. But as soon as the distance is larger than 1.5 meters, the presence of obstacles, the kind of device you're using, even the humidity of the air can influence a lot on the accuracy, which means either many false negatives or many false positives, depending on how sensitive you want to tune the thing. But of course, you prefer false positives rather than false negatives. So, I mean, we have to cope with the fact that with Bluetooth, you can be traced as in contact with somebody who is on the other side of the street on another bus, while you are on a bus on this side of the street. You are very far away. There is enough social distancing, but still Bluetooth may reveal it as a false positive. Same for GPS, I would say, because for GPS, it's a different kind of problem. The coverage of GPS changes a lot along the geography of countries. So in some places and outdoors, it's very precise, but in some other places or indoors, it's not very accurate. So as far as accuracy is concerned, both technology failed miserably.
Thank you very much. I think it's clear that we do need like human intervention in this whole process, as Professor Derdy mentioned. And I think I will pose you to Dr. Wojciech one question that was written here in the chat regarding the data retention period of this data. So one of the concerns is how players, private players and governments, they will process this data. And so are there any guidance from the DPS or from the European Data Protection Board where you secretariat and so on? So are there any sort of, like, say, common approach on the maximum retention period for this data? And then we had an extra question that it's much more sort of follow up on what Professor Drake said, the idea of using, let's say, automation for taking decisions. You know that in the GDPR, and there was already in the previous directive, this prohibition of an exclusive decision based on automation that could impact somehow the rights of people. In that case, if an application such as those tracing applications target someone as being in contact with these people, with someone contaminated, if there would be no such a human, let's say, action from the side of the health authorities, we risk that someone will have their right to move impacted by the use of such technology. So such person will need to be at home for some days. And we know some examples that in Italy, that people that downloaded the application, that received that message and contacted the health authorities just said that they should stay at home for 2 weeks. So how do you see first the retention limits, if there are any guidance, and if you could also, let's say, apply this prohibition from the GDPR on the need to have a sort of human appeal for the decisions taken by these applications?
Thank you very much for these questions. Let me also add one thing to what Professor Boldi said. In the question, there was also the question about the telecom operators and their data. Can it be used instead? And here we can say that although many of us know that there is a possibility to track the person using the telecom data in a very precise way, we have to bear in mind that this is not the normal activity of the telecom operator. The telecom operator can do such tracking, but usually it's not, because it's absolutely not necessary for anything. And there is no technical possibility to do it to all thousands of people which are at the same time in one cell. The cell might be quite big, and everything that operator needs to know, the telecom operator, is that the person is in this cell. And that allows to direct the communication there. But of course, there is a possibility to go much farther and to track the person much more precise, which is done when the police, for example, is expecting that. But this is not the normal procedure. This is not the normal activity. And moreover, it meets the same technical problems as Professor said about GPS. So the more you are inside the building, the less effective it is. And also, if the building is a high building, this dimension is not well covered by this kind of tracking. Okay, about the retention data, that's a very interesting question, because the question would appear only if we think about the personal data. So the question is how long the government is storing the data about the person, who is the personal data in this contact trace application, is first of all the question, do they have any data, which is the personal data there? Because they will have something at the moment where there is a match between the data, and at the moment where they got to know that the person has been positively tested. There is no all-European guidelines apart from the general advice to have it decided at the moment when the application is created. Most of the countries that I know about took the idea of 30 days as the general time for the storage of the data. bearing in mind that the longer storage is not necessarily, it's not necessary. So after this 30 days, the data has to be either erased or more often anonymized, which of course creates another problem. What does it mean, effective anonymization? But let's leave it for a while, for a while aside. So 30 days, that is what is a kind of usus at the moment. But the general guidelines are only saying about the necessary period and to have it decided decided before. By the way, that was also the reason for which the Norwegian authority had the problems with their application, because they said, okay, we have 30 days of anonymity of the period that you can store the data, and then you have to anonymize it, but you just forgotten to prepare the tools to anonymize that. You don't have even the procedure, your government, how to anonymize the data. So it's nice that you said that you will do it after 30 days, but there is no information how you are going to either anonymize or erase this data. So these are the things which are appearing here. There was a second part, sorry, that you asked.
Was the part on the use of automated decisions?
Automated decision, of course. Well, once again, the question is it an automated decision that has the legal or other specific meaning for the person? Because you have to remember that this is not the decision in the meaning of administrative law. And nobody has given any decision that will affect directly your life. Of course, indirectly, you are right. Yeah, indirectly, you are right. Because if I get to know that I was next to the person like that, and if I contact the health authorities, I probably will be advised to go to quarantine together, probably with my children that were with me, despite the fact that I don't know precisely when this contact appeared, because I would be very happy if what Professor Boldi said was right, that you have the precise information on when it happened. That's in Italy, as far as I know, but it's not true in the other applications, because they think that this is intrusion in the privacy, because it tells you who was the one who might be infected. Yeah, and this is not necessary for you to get to know that you were under the danger, which on the other side is quite strange, because I can't say at the moment I'm not in the contact with anybody who is infected, because I'm the only person who is in this flat, while probably over this wall there is somebody else who is infected and whose data would be collected by my telephone. So the information about the precise time when the data was collected might be even useful to reduce the number of false positives. Yeah. So there are some additional points to be taken into consideration. So I'm not sure if it's always the automated decision in the meaning of GDPR, but of course you are absolutely right. The GDPR is including the note like that. Let me say at the end about the paradox that we get about that. Well, sometimes people prefer, if the decision is automatic, than to have the man doing this. For example, if there is an information that the provider of the mail, email, is checking your mailboxes, people have no problem if it's done by the machines who are checking and finding the correlations with the probable advertisement to be given to you. But people don't like the idea that somebody sits, reads, and decides. So sometimes, more and more often, people right now say we prefer to be that to be done automatic than to be done by man. But you are absolutely right that GDPR says about the necessity to have the human factor in the decision process.
Yeah, I think it's just an example of maybe a practical consequence of the use of such technology, because of course they are not envisioned to do this way. There should be an extra sort of task force to follow up on the identification of this done by these technologies, to, as Professor Derdi mentioned, so to allow people to undertake blood analysis and so on. And I think there is but of course in practice we see that many states, they are not well prepared to use these technologies, and so the results seem to be not proportional at all. So the use of this technology, if they don't achieve the purpose they are intended to have, so it's really useless. But I think it's a point to be addressed, and I will now go. So the questions, they are popping up in the chat. So we have like dozens of questions, and I will now address this question to Professor Curtin. A bit on a follow-up on what you started to address regarding the role of private players and the use of technologies and the creation of these huge databases, and what could they do with the use of such data. So there's one question, if you see any competition concerns in this regard, and what these private players acquiring this data can use in the future, for instance, this sort of data for enhancing market power. I know that it's a very competition law question, but if you could, let's say, give your first impressions on this issue, I think it would be really useful.
Thank you very much. So, you know, when there are players like, and of the size and power and magnitude of Apple and Google involved, then I think there are always competition concerns, and also in terms of market advantage and their ability to use data to enhance even further their market power. I mean, I think we have to see these questions also in the more general context. Whether that, I mean, it all depends. There isn't a general answer to this question because it varies at the moment. We don't know what provision has been made in terms of time, in terms of the data being erased, all of that. So a lot of the things that I was referring to in terms of sunset clauses and time limitations and all of that could play into their ability to use data for other purposes, so not strictly purpose limited, the purpose for which the data was gathered. So one thing I would say more generally is that there is a need for us to see, you know, not fighting on the ground, as it were, while this is ongoing, but also with a little bit of time to look at it. I think we need to place these issues in a broader context and see what we're learning from what was suddenly possible in this context for the very real issues of health globally, and where that potentially leads us, both technologically and in terms of law. And law is always behind, you know. It's not a matter of saying, oh, there's a nice legal provision up there, be it of administrative law or constitutional law or whatever, and then we can apply that. So often there is a gap, and it's more about, you know, catching up. In terms of the, just one last point, if I may, the comment by the European Data Protection Supervisor, it's true that people may prefer not to have a human snooping in their email or elsewhere, but also we are seeing more and more challenges where there are negative decisions, where profiling has been going on in terms of social welfare, in terms of education, access to education and others, you know, be it in Italy, the Netherlands, or wherever. And I think in that broader context, you know, the balance between automated decision-making and human intervention is really important. So, you know, my real point is that we have to view this also perhaps ultimately in a broader context as well. And maybe as academics, we have hopefully more time for that also later when this crisis is over.
When this crisis is over. No, thank you very much. You made a very good point. I think all your points were really, really good. I do have, like, I'm really facing some difficulty in choosing the questions because we have like a long list of questions. I do have still some questions for Professor Paulo, for Dr. Wojciech, and some general questions. There are some issues regarding transparency that were addressed to Professor Paul in terms of if you have any knowledge on initiatives to trying to get from Google and Apple information on more transparency on let's say, on the code of their applications. There is also a question on one issue that was raised by Dr. Wojciech, but they are asking from a more technological perspective, the issue of anonymity of data, if it really exists from a more technological. I know that's a long debate. We could go the whole day just discussing anonymity and the anonymity from the technological point of view, but from the data protection point of view. So I think we do have this issue. Maybe Professor Paulo could address these two issues, the issue of anonymity and the transparency of these applications of the big players, so Apple and Google mainly.
So no, I don't think it's possible to ask for them to open source their APIs, because they are all interdependent. So there is no way to make only the notification exposure API open source. Even if they will, it would be useless, because they would have to make all their code open source. But there is no need, in fact, to rely on those apps. There are countries, I think in France, they did decide for an application that is similar to the Italian one, but does not use the notification exposure API. Given this, anyway, I wouldn't be too worried about what Apple and Google can do, because honestly, I don't think they can do much, because their APIs are, I mean, so simple that it's even difficult to conceive that they have a backdoor to do something nasty with the data. So I wouldn't be too worried under that viewpoint. I'm referring to the notification exposure API only. From the perspective of computer science, anonymity exists. I'm myself an expert on this. It basically reduces to cryptography, and cryptography does exist. So cryptographic methods exist, and for example, the kind of data that are generated in these Bluetooth-based applications are cryptographically secure. So as long as you believe that it's difficult to make an ATM if you don't have your ATM card, you are secure under that viewpoint. I'm not saying that it's always easy to achieve anonymity, but in this specific context, a measure of anonymity can be obtained. About what Wojciech said earlier, it's true that the current version of Immuni only says 2 days ago you met a dangerous person. It doesn't say 2 days ago at 2 p.m. But that information is stored on the device anyway, even if it's not shown on the display.
Oh, well, I think we are coming to an end of this. I would ask you to use maximum 1 minute per person to give your, let's say, final comments, and then we close. Unfortunately, we'll not be able to answer all the questions that were written on the chat, but I think it was really a very good, let's say, a very good debate. And if you could just address your final remarks in 1 minute. We can start by Dr. Wojciech and then Professor Kurting and Professor Boldi.
Okay, I'll try to use 10 seconds per anonymization and 10 seconds per the conclusion. The 10 seconds per anonymization will be, theoretically, there is a possibility to make the, theoretically, there's no possibility to make the full anonymization of the location data if you don't encrypt it, yeah? So removing the part of the data does not, cannot 100% give the results of anonymization, but we are rather thinking about effective anonymization. And the conclusion, I would like to say again the sentence which I started with, that me, myself, I'm going to download the application and use this application. And at the same time, I'm going to ask to the governments what is going on with my data and how is it used. And if I will not see if it's effective, I will go out of the scam.
Thank you very much, Dr. Wojciech. Professor Kirking, if you just could give your final remarks in 1 minute maximum, please.
Unmuted, right. I think one very important issue, I just limited to 2 remarks, that a lot has happened in the context of this emergency that was thought not to be possible before, in terms of locating access to data, sharing it, using it. And I think it must be looked at very carefully also what the broader implications are in terms of other purposes. I think that's fundamental, and other public use by other public authorities, either national or European. I think it also illustrates the need to deepen the debate on what transparency means in this context of data, and the use of algorithms and code, etc. And also that is a very important part of, which hasn't, a word that hasn't been mentioned today, but of course is part of the broader context, accountability. Accountability for everything that is and has happened, and how that will play into all our futures. So I think I just leave it at that. Thank you very much.
Thank you very much, and I will now pass the floor to Professor Paulo for his last remarks.
Yes, I think that what Wojciech said is the most important thing. The ratio between usefulness and possible dangers, possible implications on privacy is what will make me choose whether to install or not an application. I need it to be useful, and I need it to be less intrusive as possible. And I think there are solutions that go on that way. It's important that you understand exactly what your country is doing and how it is ensuring transparency and accountability of the data.
Now I can just thank you, all the speakers, for their great interventions. I think it was really interesting seeing the different fields from the technological perspective, legal, data protection. And I also thank the attendees. We have like many questions in the chat that unfortunately we're not able to address all of them, but I hope they enjoyed the discussion, and well, let's hope to see you again soon. So thank you, everyone. Thank you to the FSR team.